This is a clip from an earlier live stream. I know you're going to like it, so the link to the full video is down below. Check it out. I'll see you over there.
Subpoenas are typically to non-party individuals. So, you could, if there's like certain companies or maybe her husband, George Farmer, he could come in through like a subpoena. You could, depose him through a subpoena of some sort. And so there's a lot of discovery tools on the table. Oh, and I did want to mention the physical examination, with respect to, could Candace Owens seek to move for a physical examination of Bridget McCrone in any way? And what would that look like and the likelihood of that? So a lot of the videos I've been posting recently and will continue to go up on my page, discuss some of these different discovery tools. And then also too, we kind of dive into, and I'll be doing this in later videos, Erica Kirk, if she were to bring a case and if that survived a motion to dismiss and move to discovery, potential discovery tools available to her and what that would look like.
So let me make sure, and correct me if I'm wrong. It seems like discovery tools kind of go from a very non-evasive to more evasive as we trek along. So maybe like an email and a memo, then we get to like call logs and bank records. And then we're getting down to like the more invasive, like again, bodily fluids and checking, stuff like that. Am I right that discovery kind of goes from the most non-evasive to the most evasive, or is that fair?
The only point I would push back on is this. If the parties are being evasive, you can motion to compel good faith responses and avoid those evasive responses. You have to obviously generally you have to meet and confer with the other side, go over with them why they are being evasive and what they can do to stop being evasive. And if they don't, correct their conduct and provide less evasive responses or more substantive responses, you can go to the judge and have that ordered that they provide non-evasive responses. And so, if we're dealing with interrogatories, requests for admission, requests for production, depositions, because sometimes, a deponent may be, I'm not going to answer that so clearly. And it could become an issue where you have to bring a motion to compel and get them to answer that. And if you win a motion to compel, you generally recover attorney's fees for the preparation of the motion.
Okay. All right, Nick, we got a couple of questions from the audience. I do have my questions that we're supposed to be going through, but I got the audience questions and there's some good ones in there. Now this one right here, Nick, this one's a little bit lighthearted, so just take it as it is. Nick, are you married?
No, I'm not married. I got to get married though. So I appreciate the question. If she knows a nice lady, let me know.
Okay, well, there we go, man. We got the J Witt love connection over here. We're working on it out. Send me your resume. We'll hook them up. Okay, I love it. All right, Nick, why do you see people say bring on a lawsuit and to sue? And the use of discovery as a way of intimidating people?
Yeah, I think that's a great question, actually. So I think whenever there's a lawsuit filed, obviously lawsuits generally bring stress to people that aren't, accustomed to dealing with them. And so I think that's the first thing is like when people hear lawsuit, they immediately think a stressful situation where, your future livelihood could be up in the air in some way and it's not certain. And we all crave certainty to some extent. And then with respect to discovery, I would just say, discovery can be for a lot of people somewhat invasive because, take, for example, this Candace Owens discovery. We may, get to look at on the request for production of documents, seek communication. So we could have her screenshot her emails, screenshot text messages related to Bridget McCrone, and she is forced to produce those. If she doesn't, she could be sanctioned and things could go against her in her own case. And so I think with that, I think a lot of people don't want their personal and private information out there, but if it's substantially related to the case, you're generally going to have to produce that type of information, especially communications in a case like this. So I think that's what scares people, is the stress and the potential in what they perceive as invasive into their own lives.
Could you speak then with that same, what you just said there, could you speak on fishing expeditions? Because I've heard people say the reason why TPUSA will not sue Candace is because of discovery. They're going to get stuff that she's going to be able to use in another, 45 pieces of content, or they're going to just fish like, let me see what were you talking to Jason about in the text message? And, I see you said this, and go in a whole nother direction. So can you speak about fishing expeditions?
Yes. And so when it comes to fishing expeditions, obviously that's going to typically occur in the discovery stage when the parties are gathering evidence. And the whole fishing part is like they don't know exactly what they're going to catch. They're just casting this wide net or throwing out a lot
Yeah.
to see what they can pull back or reel back. And, if it's invasive, so be it. And so a lot of people, when fishing expeditions are just very overwhelming to a lot of litigants. And then with the legality of that, you just have to push back on each question. So if they try to seek, like let's say tax records, right?
Yeah.
Well,
Oh my gosh.
it's a business. So, the tax information is not as protected as it would be for an individual human being. And so, when it comes to TPUSA suing and they're going to argue reputational damage, and then, with the reputational damage, they might have to show certain aspects of financial loss. We're dealing with, the scope of discovery is going to be able to get all of that all those documents. And so I do believe TPUSA should have a concern related to the disclosure of their internal documents and information processing. And that's not always fishing, because at the end of the day, the scope of discovery is much wider than just the definition of relevance. You don't have to ask a discovery question or request that's exactly relevant, if you will. You just have to ask it within the legal scope of discovery, which is generally, trying to gather facts or information related to claims or defenses. And so long as you can argue whatever you're asking is sufficiently related to the gathering of information or evidence related to this claim or this defense, you're going to have to provide that. And so generally, just because the scope of discovery is broad, it generally permits a lot of fishing expeditions, if you will. And then the lawyers just have to do a good job either objecting to that, requesting motions for protective orders, or if the trial comes up later, ensuring that whatever evidence, was turned over that, they don't want admitted at trial, they have to identify it and then move to suppress it.
So just to ask, okay, I'm suing Nick. Nick is suing me. We're suing each other, and I want your tax records. You want my tax records or bank statements or whatever like that. And I don't want you to see that I have a problem at the Adidas store, man. I go to the Adidas store entirely too much. I spend a lot of money at Adidas, and I don't want you to know that, because you're going to put it out there that I'm an Adidas addict, which, by the way, I am. But I don't want you to put it, I don't want you to have evidence to the fact that I'm an Adidas addict. But that's not even related to our lawsuit. The lawsuit is about whether or not I have a blue Stanley cup on my desk. So can I get that redacted from there, that the fact that I go to the Adidas store entirely too much? Or do I truly have to give you all of my bank statement and you can, how does that work as it relates to, I hope that makes sense.
So the way I would kind of approach that question is, imagine you and I had a case involving a battery and assault. Either you hit me or I hit you or something like that, right? It's pretty much an intentional tort involving you and me in that sense, and there's no financial allegations to it. It's just you or me caused each other physical pain. And so if we were doing discovery on this, proper discovery would relate to that battery, such as what emotion did you feel right before you made contact with,
my face.
Exactly.
Right.
Did you have anything that happened within the last hour that had caused you, to be emotionally negative or something of that nature?
I spent too much money at Adidas, man.
Yeah.
I spent a lot of money at Adidas. Now I'm stressed, man. I see you and then I beat you up.
Yeah, exactly. Yeah. No, but if you ask for financial information because of a cause of action related to battery and assault, that's not really gathering information or evidence related to the claim or the defense, which is going to be, battery and assault. And then maybe, my or your defense would be self-defense because we likely fought back or something. And financial documents aren't really relevant, nor are they within the scope of discovery purposes of proving those claims. Now, if you were successful in getting a judgment against me for battery and assault, or I was successful against you, now we need to figure out each other's assets and what do we own. And if it's $1 million or something like that, the judgment, it's a hard punch.
I'm hurt, man. I'm hurt.
The pain and suffering is getting to you. I can feel it.
I know you liked that episode. This is actually a clip from a larger live stream. The link is down in the description, so you can go check it out. I hope you enjoyed it, and I'll see you down there. Grace and peace.